Welcome to this video titled, "What's Wrong with Your Miranda Rights?" Please pay attention to this disclaimer. Any statements on this video regarding the behavior of law enforcement are to be considered only as the beliefs and opinions of the creator of this video. Watch any other applicable videos, read the commentary here and make up your own mind. The material presented here is for information and entertainment only. It is not intended as professional advice of any kind. Specifically, this is not legal advice. If legal advice is needed, contact a licensed attorney in your state. Anybody who has watched the cop show in the last 20 years knows about Miranda rights. The reading of your rights to you by a law enforcement officer always begins with "You have the right to remain silent." It's called being Mirandized. If you need to refresh your memory on all of your Miranda rights, just read the information on the screen. Here's how it sounds. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand the rights I have just read to you? With these rights in mind, do you wish to speak to me? So, what's wrong with this picture? If reading these rights to you is a mandatory procedure, how can this case law that has been the law of the land for over 50 years hurt a person when dealing with the police? While this law is important, it can give you a false sense of protection. There is a condition that has to be met before Leos have to read you your rights. That condition, or exception, can easily put you in jail. Police can delay reading you your rights until you are actually placed in custody. In other words, your freedom to move freely has been eliminated by the police. If you are engaged with police in a consensual conversation, they can ask you questions all day long. If you are simply being detained for a brief interrogatory stop, commonly known as a Terry stop, cops can ask away. Doesn't mean you always have to answer. During a street encounter, you can always state that you don't answer questions from law enforcement without a lawyer. You can say, respectfully, "I am remaining silent." That's your Fifth Amendment constitutional right, protection against self-incrimination. The fact is that, anything you said to police, anytime, can and will always be used against you in a court of law. It's my understanding that law enforcement can ask questions up until the point it becomes clear there is probable cause to make an arrest. At that point, the requirement to advise you of your Miranda rights would be triggered and the handcuffs would come out. At least, that's the theory. The best practice is to never answer questions from the police unless you have a lawyer present. So, how would that play out in real life? Scenario number 1, consensual encounter. In this instance, a peace officer walks up to you and starts to engage in conversation. After perhaps a polite hello, my response would be, "Officer, I know you're just trying to do your job, but I have nothing to say to you. Am I free to go?" If the officer answers, "Yes," you now know this is a consensual encounter and you are free to go or free to stay, but you don't have to answer any questions. And you can walk away whenever you want. Police are not usually required to tell a person that he is free to decline to answer questions and go about his business. You have to ask, "Am I being detained or am I free to go?" Now, let's examine the second kind of contact with law enforcement. You will find that presentation on part 2 of this video series titled, "What's Wrong with Your Miranda Rights?" Please go on to the part 2 video now.